Hi guys, welcome back to Nairobi Legal Insights. In our video this week, we're going to be focusing on performance of a contract of sale. This is a topic under sale of goods, and in our next slide, I'm going to be providing an overview of what we intend to achieve in the course of this video. Now, should you be a student interested in commercial law in Kenya, then consider subscribing so that you receive notifications every single time I'm going to be posting a video on sale of goods, specifically under the commercial law section on Nairobi Legal Insights. Just to add context to this particular video, I introduced the topic of sale of goods, and so this is just a build-up from the previous commercial law videos I've done. You can please refer back to that playlist on commercial law in Kenya so that at least you watch the previous videos and we get some sort of a flow. For this specific video, we're going to be focusing on rules of delivery, and by the end, you must be in a position to discuss these particular rules of delivery in a particular order so that you understand each one of them much better. And then you must be able to actually look at facts and be able to look out whether delivery has taken place or whether the seller has done his obligation to deliver the goods. Remember, the essence of this video is to look at the duties of a buyer and a seller in commercial transactions. And so you need to be able to look at a contract and examine it and be able to understand, has delivery taken place? What was the agreement of the parties? And for you to be able to process these rules of delivery, then consider watching this video to the end so that you get the entire overview of this discussion. In our discussion, we're going to be focusing on sections 28 to 38 of the Sale of Goods Act, basically looking at the duties of a buyer and a seller regarding the performance of a contract of sale. And when you go straight to section 28, it provides that the seller must actually deliver the goods while the buyer has a duty to actually accept these goods according to the contract. Now, over and above this, when it comes to delivery of these particular goods, unless it is otherwise agreed by the parties, and this is an exception, delivery and payment of the price for the goods must actually occur concurrently, meaning that if you buy a burger from Java and it's delivered to you, then as the burger is being given to you, then you must actually also go ahead and pay for that particular burger. However, by closely looking at section 28 of the Sale of Goods Act, we have an exception which provides that unless otherwise agreed in a contract for future goods or unascertained goods. So there's an exception where a delivery may occur, but payment will not actually occur concurrently. And if you want to understand what does a future or unascertained good mean, then refer to the video I made on unascertained goods so that you get a proper understanding of these two key terms. Now, before we go into the specifics on the rules of delivery, I want us to first have a look at the duties of a seller so that we have these 4 key points at the back of our minds. Now, the first duty of a seller is to deliver goods in accordance with the terms of a contract. An example here would be that if Rogers and Linda enter into a contract for delivery of 40 boxes of water, Rogers is the seller selling to Linda 40 boxes of water, then Rogers has a duty to deliver those goods in accordance with the terms of the contract that have been set out between Rogers and Linda. Now, the next key duty for a seller, in this particular instance, Rogers is the seller, he has a duty to transfer the property in the goods to the buyer. Now, when I talk about transferring property in the goods to the buyer, what I mean is that Rogers must transfer ownership he had in the bottles of water, or rather the boxes of water, to Linda. Now, this takes us to the next key point, which is that a seller must deliver to the buyer goods which accord with the terms of the contract, express or implied. And we talked about what does, or rather we discussed what express or implied means in our previous videos on commercial transactions. Or rather, to be more specific, on sale of goods under the playlist on commercial law in Kenya. So have this at the back of your mind, meaning that whatever Rogers and Linda discussed pertaining to delivery of the boxes of water, how many bottles should be in each box, all those conditions have to be met. And that by the time Rogers is delivering these boxes of water, each box must be in accordance to the terms that Rogers and Linda agreed on. Now, lastly, a seller has a duty to deliver the quantity of goods he agreed to sell to the buyer. Now, using the same example of Rogers and Linda, if Rogers and Linda agree that Rogers, who is the seller, is supposed to deliver 60 boxes of water and each box must contain 24 bottles of water, then in that particular instance, not a single box should have less the number of bottles as per each box was concerned. This goes to show that you must actually deliver the quantity of goods that you agreed as a seller with a buyer. And remember, there are certain exceptions to this particular point that you're going to be discussing in more videos to come. Now, having discussed about the duties of a seller, at this point in time, I want us to understand delivery. Remember that in any sale of goods transaction, we have a seller and a buyer, and these goods have to be delivered to the buyer. Yeah? And having understood the duties of a seller, I want us to be able to understand what does the law say as far as delivery of goods is concerned. And before we go into that discussion, I want us to first understand, to begin with, what does delivery mean? Now, when I talk about delivery, what I mean is that it is the voluntary transfer of possession of goods from one person to another. So out of your own free will, you transfer the possession of the goods you've sold to someone, and that person is going to have physical control over those particular goods. Remember, taking you back to the previous videos I did on sale of goods, I stated that there was a distinction between ownership in a good and possession of a good. Now, if I have my car and I give it to James, what James has is possession of my car, but not ownership. Ownership still belongs to me. So you need to get the clear distinction between ownership and possession, because those two words mean two different things legally. Now, as far as delivery is concerned, it may be actual delivery where you actually hand over the good to someone, or it may be constructive delivery. And at this point in time, I want you to pay close attention to constructive delivery, because when it comes to constructive delivery, the goods are not delivered, but the means of obtaining the possession of those goods will actually be delivered. An example here would be that if Rogers sells cars in Nairobi and Rogers happens to have sold a car to James, now constructive delivery would be that Rogers is going to take, maybe Rogers has locked up his place where the cars are parked. Then he gives the key to James and he tells James, the car you bought, you can actually go open that garage, then you'll have access to it. That is constructive delivery. Rogers has actually given James the means of obtaining possession of the car he sold to him. So you need to be able to read facts to depict whether there was constructive delivery. But the overall key point of this specific slide is for you to understand, if parties to a sale of goods contract have no stipulation as to delivery of the goods, then the default rule is that the rules of delivery are going to apply, and these rules are found in the Sale of Goods Act. We may have a contract between a seller and a buyer, but in this particular contract, the seller and the buyer do not agree or do not have any stipulations or terms that are going to guide the delivery of goods from the seller to the buyer. This is a sale of goods contract that lacks that. There is no guideline as to delivery of those goods. Now, when it comes to performance, a dispute may arise, and because the parties did not agree at the onset on the stipulations regarding how goods are going to be delivered, then the rules provided under the Sale of Goods Act of Kenya are going to be used to resolve such a dispute touching on delivery of goods. And as far as this is concerned, I want us to move to Section 31 of the Sale of Goods Act. which provides, in simple terms, that the place of delivery is the seller's place of business. Where the seller operates from, that becomes the place of delivery, where the buyer is supposed to pick the goods. And there's an exception within this section which provides that the seller's residence can also be considered the place of delivery, because we need to be aware of the fact that not all sellers have business premises. Now, moving on to the next rule of delivery, which is under section 32. Now, where the seller is bound to send goods to the buyer, but there's no fixed time as to delivery, then that delivery must actually be made within a reasonable period of time. If you ordered for goods and they're delivered 2 years later, obviously using reason you can tell that maybe by the time we're entering into this contract for sale of goods, the reasonable time for delivering these goods was supposed to be 2 weeks and not 3 months. So that is very, very key to have at the back of your mind. Now, the third rule is that delivery must be at a reasonable hour. Otherwise, it may be treated as ineffectual. An example here would be that if I order for a burger for lunch to be delivered to me in the next 1 hour, then it's delivered to me the next day or 2 days later, you can already tell that the delivery was not within a reasonable hour. And this is a rule under section 34 of the Sale of Goods Act. So most of the times we do these things without knowing that they're just normal transactions, but the law has actually provided the rules that guide delivery of goods when it comes to a sale of goods contract. Now, it is also very critical to acknowledge that we may have situations whereby we have a buyer and a seller. The seller hands over goods to a third party to deliver those goods to the buyer. In this particular instance, for delivery to be considered to have taken place, then that third party, who could be a transport agent, must acknowledge to the buyer that he has received or he has in possession the goods from the seller. And once this acknowledgement has been received by the buyer, then delivery will be considered to have taken place. Now, such an acknowledgement for a law student is what we call atonement. And in simple terms, it is the possession of goods by a third party. There may be certain instances where the seller has been authorized or is required to actually send goods to the buyer through a third party, and this third party could be a transport agent. Now, so long as the buyer has authorized the seller, whether that particular third party is named or not, once the goods are handed over from the seller to that third party to deliver them to the buyer, then at first instance, delivery will be considered to have taken place, and this is in accordance to section 33(1) of the Sale of Goods Act. Now, the next key section I would want you to actually look at is section 33(3), which talks about carriage involving sea transit, especially for people who import cars from Japan. Now, we may have a seller. The seller is in Japan, the buyer is in Kenya. Once that car has been actually put on a ship and it's being brought to Kenya, then the seller is required to actually give sufficient notice to the buyer about this car that has been put on the ship, so that the buyer can go ahead and insure the car, because anything could happen during the transportation of the car. Now, in any circumstance where the buyer, or rather the seller, does not actually give this sufficient notice, then any risk that happens to that particular car while it is on transit will actually be the seller's risk. And this is in accordance to section 33(3) of the Sale of Goods Act. And just again, maybe to remind you that in the event that parties to a sale of goods contract do not agree or do not have any stipulations as to how delivery of goods will be done, then the rules set out in the Sale of Goods Act will be used to resolve such a dispute. When it comes to the sixth rule of delivery, the expense of putting goods into a deliverable state is actually borne by the seller. So whether it's packaging, whatever you do to the goods to ensure that they're in a deliverable state, is done at the cost of the seller. And of course, most sellers would factor this cost into the price of the good. Moving on to the seventh rule of delivery, I want us to pay close attention to section 34 because it provides that if the seller agrees to deliver goods to the buyer at a place other than that where they are when sold, in this particular instance, and let me use an example to bring out this section clearly. If I go to town and I buy a laptop, I pay for the laptop, I'm given a receipt, I am the owner of that laptop. Then I choose not to carry that laptop home. But as I make this choice, we have no agreement with the seller that should anything happen, then the seller is going to bear the risk. In this particular instance, because we don't have such an agreement, if that laptop is being delivered to my place, remember I've bought the laptop, I've left it in town, and I've told the seller, bring it to my place. I've given the seller the location to my place, but we have no agreement as to what can happen or who bears the loss in the event that that particular laptop is stolen along the way. In this particular instance, any risk of deterioration incident during the course of transit is going to be borne by me. Maybe that laptop falls off the motorbike as it is being transported from the seller's premises to the buyer's premises, and there was no agreement as to what will happen should any risk occur. In this particular instance, me as a person who went ahead to tell the seller to deliver the laptop to my premises, I'm going to bear that risk. So that is the essence of section 34 of the Sale of Goods Act. Now, the other key thing we need also to note about this specific section is that if the seller agrees to deliver goods at the buyer's premises and without the seller's negligence, meaning that it is not your fault, you go ahead and deliver these goods to a third party who had been authorized by the buyer to receive those goods on the buyer's behalf. Now, should that third party go ahead and cause any damage to those goods, the loss is going to fall on the buyer and on the seller. Meaning that once I deliver the goods to this authorized person who is receiving them on behalf of the buyer, anything that happens beyond that is the risk of the buyer and not the seller. Now, did you know that also a buyer can be liable to a seller for failure to actually take delivery of the goods? This happens where the seller is ready and willing to deliver goods to the buyer, and the seller sends out requests to the buyer that come and take delivery of your goods, or I'm ready to deliver goods to you. But this particular buyer does not comply within a reasonable period of time. So let's say you've bought goods and they're supposed to be delivered within a week. You take about 4 months to respond. You don't take delivery of those goods. In this particular instance, as a buyer, you're going to be liable to the seller in two different circumstances. Number one, remember that after goods have been sold to you, those goods are under the custody of the seller and occupying space in the seller's premises. Those are no longer the seller's goods. So you can be actually charged a certain amount of money for the care and custody of those goods because you refuse to take delivery within a reasonable period of time. And also, any loss occasioned by your refusal as a buyer to take delivery will also be charged upon you as the buyer who refused to respond to such requests of taking delivery within a reasonable period of time. And this is pursuant to Section 38 of the Sale of Goods Act. This brings us to the end of the 8 rules of delivery. We've discussed about Section 28 all the way to 38 of the Sale of Goods Act. If you are a student watching Nairobi Legal Insights for the very first time, consider subscribing so that you receive notifications every single time we post a new video. You can also share your comments below so that we can respond to them. And if you liked the video, you can share it with your friend so that we continue learning from each other. Thank you and see you next time.